All right, let's call a case.
Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pre-trial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tanea Tubbs.
Ms. Tubbs, if you can state your name for the record, please.
Grand Rising. I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tanea Nicole Tubbs, the beneficiary.
Okay, and Ms. Patilla is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that, but if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you. Okay? You're gonna represent yourself, but if you have any questions, you can ask her. All right?
I hear you, sir.
All right. Do we have a jury trial date on this?
March 17th.
All right. We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial
and I have ruled that she can represent herself, haven't I?
Yes.
Okay. All right.
And that's why the other counsel was relieved and
Right. Okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public would not hear.
When a court keeps something private, it is not about hiding the truth or blocking the public from hearing it. Plea negotiations are confidential because the law is designed to protect honest and open discussions between both sides. This privacy allows attorneys and prosecutors to speak freely without public pressure or misinterpretation. It has nothing to do with secret rules about licenses or registration. It is simply a standard legal practice used in courts everywhere to ensure fair negotiations and proper procedure.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patella?
No, sir.
All right, Ms. Patel, I don't think I can order her to do that. So, Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. what would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping.
Believing that a divine force will appear in court to argue your case is not how the legal system works, and history shows that this approach ends badly every time. I have covered cases before where defendants claimed a higher power would defend them, and the outcome was severe sentencing with real prison time and no miracles involved. Courts operate on evidence, procedure, and law, not faith-based arguments or symbolic gestures. If the state is offering you a qualified attorney at no cost, that is not an insult, it is an opportunity to protect your rights and your future. Choosing real legal help over imaginary representation is the difference between a fair defense and a life-changing mistake.
Not being
Oh.
smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Miss Tubbs. So she apparently, will you be willing to have Miss Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you. I'm not willing to.
All right,
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
So you're
You tell
forcing
me.
me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to me. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell
She
me.
can have
what you
her
want.
in the courtroom, but not on my behalf. It could be on her behalf since she's fearing what I have to say alone. I'm
All
not
right,
understanding
then
why.
put the three of you in a breakout room to discuss things.
Okay, thank you.
Okay.
Do you agree to that, Ms. Tubbs?
I agree to speak with her with
Okay,
the third party on her side.
all right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay.
Okay,
I'll
thank you.
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
A few moments later.
All right, let's call Ms. Tubbs' case, please.
Calling case 2400390201, the people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozek on behalf of the people, P78815.
And good morning, Judge Dion Patillo, PA2378, stand-in counsel for Miss Tanaya Tubbs.
All right, Ms. Tubbs, if you can unmute and state your name for the record, please.
For the record, I am Tanea Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. You agree to waive that right for today and hold this hearing by Zoom?
Correct.
Okay, all right, where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs, and I did look up the, I know that the defendant is in Calhoun County Jail right now, and that she has a sentencing date of March 24th, 2025. When is our trial date? The
March
17th?
17.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here, and maybe we should have a pre-trial before the trial once Miss Tubbs is here, where we're all in person. And Miss Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th if that works for the court, prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay. All right.
Excuse me, Your Honor.
Yes, go right ahead, man, Ms. Tubbs.
I am looking forward to being out of here before then, and it is my duty to come there on my own as a freeborn sovereign to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district, and I'm not going to be able to get this paperwork if I don't be able to walk and go home and print it out myself, because I have none but 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to help me any longer.
This situation reflects a troubling pattern where responsibility is ignored despite having many children depending on stable care and support. When a parent refuses to follow basic laws, it places the entire household at risk and creates problems that did not need to exist. It is hard to overlook the contradiction of rejecting the authority of a system while at the same time depending on public assistance to meet daily needs. The very structure being criticized is often the same one providing food, housing, and safety for the family. Personal choices matter, and accountability becomes even more important when others rely on you for their well-being and future stability.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're going to be in the jail here, Wayne County Jail.
What I'm telling you is that I'm going to be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity, or am I an entity? I am a living being.
You haven't.
Being in custody while having many children depending on you is not a life choice most people would ever accept or defend, because it removes your ability to provide guidance, support, or stability. When someone ends up behind bars, it is not just their own freedom that disappears, but their responsibility to their family as well. That reality brings the first hearing to a close and sets the stage for what comes next. The second hearing takes place in Judge Chisholm's courtroom, where self-declared sovereign citizen attempts to argue his way out of trouble. Instead of making progress, his claims fall apart almost immediately. The courtroom staff and officials see through the arguments, and the moment quickly turns into a clear rejection of everything he presents.
Someone has come online from an iPhone. What is your name, please?
My name is Kimash Myrick, special appearance today.
I will admit this sovereign citizen managed to be memorable because he made what he called a special appearance while positioning himself in a way that completely defied common sense and courtroom norms. Instead of focusing on the substance of the hearing, he turned his entrance into a performance that distracted from any serious legal discussion. The moment summed up the entire approach, where style replaced substance and spectacle replaced reason. It was another example of how these tactics draw attention but never bring real results in a court of law.
You're going to have a chance to speak with Attorney Gagnick before the arraignment. And you'll see on your screen an invitation to join a breakout room. And we're going to go to breakout room 2. So when you see the invitation to join, please join.
Magistrate, Mr. Myrick declined counsel.
Okay.
I'll just have him acknowledge on the record, and then I'll let you take it from there.
We've got Mr. Myrick coming back. We'll close the room.
I get the impression that he may be filing a special appearance on behalf of a sovereign citizen.
Okay, we've got Mr. Myrick back. This is 25-00183. People of the City of Berkeley versus Kamash Daku Myrick.
Magistrate, I'm just going to acknowledge my presence for the record. Patrick Gagnick. I'm here as appointed counsel on behalf of the arraignment docket this morning. I did speak to Mr. Myrick in private. I did explain to him he does have the right to counsel. I explained to him, obviously, that right. He's indicated to me unequivocally that he does not want counsel. Mr. Myrick, is that a fair statement?
That is a fair statement.
So with that said, I'm here and present, but with that, I believe Mr. Myrick will address the court on his own behalf.
Mr. Myrick, you have the right to decline counsel. You also have the right to change your mind. If you do, just notify the court.
Yes, sir.
You've been charged in this citation that was issued on the 22nd day of January at about 5:58 in the morning with driving in the city of Berkeley on Henley near Franklin Street while your license to do so was suspended. Driving on a suspended license is a crime for which you could be incarcerated up to 93 days and or fined $500. You have a right to a trial. Trial can be before a judge or a jury. You can act as your own attorney or you can be represented by counsel. If you cannot afford to retain your own attorney, an attorney can be appointed for you. You'd have the right to confront and cross-examine the witnesses against you. You'd have the right to testify yourself or not to testify. In the event that you choose not to testify, your silence cannot be used against you. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. The court's going to enter a plea of not guilty on your behalf.
No, sir. I don't even understand the charges.
That is exactly why attorneys exist, because complex legal problems are not meant to be solved by guesswork or pride. If your freedom depended on solving a difficult equation, it would make no sense to rely on limited skills when an expert is available at no cost. The courtroom works the same way because law is technical, precise, and unforgiving. Choosing professional help is not weakness, it is common sense, and it is often the difference between protecting your future and making a costly mistake.
Charge is driving a car on the streets of the city of Berkeley while you're not licensed. You're suspended. That's the allegation.
Well, I totally understand, and I would love to plead, Your Honor. But before I have some questions on the record before moving forward and concerning the subject matter of the jurisdiction and the nature and cause of the action that's brought against me.
The nature of the cause brought against you is a criminal charge.
Okay.
Alleging that you were operating a motor vehicle on the streets of the city of Berkeley while your driver's license was suspended by the Michigan Secretary of State. That is the nature of the charges brought against you.
Thank you, Your Honor. For the record, are you saying that these are criminal charges?
Yeah.
Okay, Your Honor. Further, that brings a little bit more confusion for me because under the Constitution, there are two criminal jurisdictions. One is under the common law, and the other one is under admiralty, and that's a military tribunal venue. And under Article 1, Section 8, Clause 17. Which one of these criminal jurisdictions am I being brought on charges of?
At this stage, the hearing was already finished and the judge had formally removed the individual from the courtroom. Instead of accepting the ruling and moving on, he chose to return and continue arguing despite the clear end of the proceedings. That decision only made the situation worse and showed a complete lack of understanding of how court authority works. Once a judge closes a matter, the discussion is over, and pushing further only adds consequences. What could have ended quietly instead turned into another unnecessary escalation that served no legal purpose at all.
Mr. Myrick, your perception as to the nature of the Constitution and its implications is grossly distorted. You're not dealing with reality.
Objection, Your Honor.
You can object all day long, but the bottom line is that what you are alleged with doing is a crime, and you are facing criminal prosecution here with a potential jail sentence of 93 days. Now, this isn't complicated. If you want to come up with words that don't make sense, keep talking. But the bottom line is that there's no correlation with what's going on here and admiralty law whatsoever. And the common law is a civil concept. We have statutes in the state of Michigan, as do all 50 of the states. The federal courts have statutes, and common law is a civil thing. There's no common law crimes.
Exactly. So you've ruled out the common law, Your Honor. So the other criminal jurisdiction that I can be brought in charges under is under admiralty, and that is a military tribunal.
There is no basis in law or fact for the conclusion that you stated, sir.
Your Honor, you
need
said
a
that
lawyer.
I'm under a criminal. This is a criminal charge, correct?
Yeah.
So which of the two criminal jurisdictions?
You haven't heard
are
what
you
I've said,
thinking
sir. This is not a matter of having the two choices that you have spoken to.
Wow.
You are misreading the Constitution of the United States, the Constitution of the state of Michigan, and the statutes that are brought against you here. There's nothing to do with admiralty. You weren't in a boat.
Well, Your Honor, you two have a sworn oath of office, correct?
I am sworn to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the statutes related thereto. And that means that I'm not going to.
So you do have a Sixth Amendment obligation to inform me of what jurisdiction.
And I think I have done that. I have told you that the people of the city of Berkeley have brought charges against you.
Well, Your Honor, the people is not a person. If I'm being brought up under criminal charges, there needs to be a corpus delicti, which there isn't.
You keep using the word. I don't think it means what you think it means.
So I'm asking you.
Do you know any other legal words? Why don't you just mix and match them here?
Well, this
maybe
is,
you could get a Department of Labor form and read a couple lines of that into this record too. Or maybe you'd like to deal with the probate code. But the reality, sir, is that you've been charged with a city ordinance violation. It's clear what the ordinance says. It's clear what you've been charged with. You have a right to be presumed innocent, and you have a right to a trial. We're going to set this for a pre-trial before the trial. You'll be notified by mail. Do you still live on Mendota?
I do, but I have.
What is your phone number?
I'm not issued a plea, Your Honor.
I have entered a plea of not guilty on your behalf.
I object.
What is your phone number?
You cannot
sir?
enter a plea. I do not. I have not entered a plea.
I just did.
Your Honor.
What is your phone number?
There is no plea that you can enter in because I didn't voluntarily enter in the plea, Your Honor. I'm asking you, Your Honor.
You want me to enter a plea of guilty?
Under the two jurisdictions that
there's not two jurisdictions.
There's only two jurisdictions that I can be charged under the Constitution,
no, that's
Your Honor.
Mr. Myrick. That's what your conclusion that there's only two jurisdictions here is absolutely without merit.
Your Honor, you said that this is a criminal charge. I'm asking you, Your Honor.
I'm asking you what your phone number is. Let's get down to basics here. You're making this very hard on yourself.
Your Honor, I
What's
have
your
the
phone
right
number?
to assert my right, Your Honor. And
What
I am
is your
asking
phone
you,
number?
Your Honor?
What is your phone number?
My phone number, Your Honor, is...
Yes, I'd like to know it.
Your Honor, we haven't even established what jurisdiction we're in.
I have established that. I told you it's the people of the city of Berkeley that brought the charges against you.
Your Honor,
you said that three times now.
You stated on the record that these were criminal charges, Your Honor. I need to have an understanding. By the Constitution, Your Honor, there are only two criminal charges.
Where does the Constitution say you have to have an understanding?
Say again, Your Honor?
Where does the Constitution say you have to have an understanding?
By the Sixth Amendment, Your Honor. The
Sixth Amendment says you have to understand.
Right to
the Sixth Amendment can't make you understand if you're being unreasonable.
Your Honor, I have the right to understand what jurisdiction that I'm being brought under, and you have an obligation to inform me of that jurisdiction, Your Honor.
Which I have done about 17
by
times.
the Constitution, under Article 1, Section 8, Clause 17, Your Honor.
Mr. Myrick, your bond is $1,000 cash or surety. It must be paid within 48 hours or there'll be a warrant issued for your arrest.
Your Honor.
That's done. We're through. Good luck.
Your Honor.
Get your own lawyer.
Your Honor, you have not given me a jurisdiction, Your Honor.
I've given you a jurisdiction 4 times. I'm not going to waste any more time.
That wraps up this hearing, and the outcome is simple because he either posts the required bond to stay free or a warrant will be issued leading to his arrest. With that resolved, we move on to the final update, which involves a self-styled activist who caused a scene in front of a firm judge and was taken into custody right there in the courtroom. This update comes thanks to Lone Wolf Usel, who tracked down public information and shared the latest developments. Credit where it is due because that effort helps complete the picture and brings clarity to what happened next. A link will be included so you can check out his work and support his channel. Now let us continue with the final part of the story.
Your Honor, I think you, there was a disconnection or something?
No, I disconnected you. If you want to continue, come to the courthouse, sir.
Your Honor?
Come to the courthouse if you want to continue the conversation.
I would like to move for dismissal.
I would like, it's not going to be, no.
I would like to move.
You're gone.
She's a beauty, we're talking. Oh my God.
At this point, it becomes clear that court orders are not optional and they cannot be answered with handmade notes or symbolic paperwork. When a judge directs someone to appear, the expectation is a real appearance in the proper format and at the proper place. Submitting informal materials instead of following instructions only shows disrespect for the process and leads to stronger consequences. Courts operate on rules, procedure, and authority, not personal interpretations or improvised responses. Ignoring that reality only guarantees that the situation will escalate rather than resolve.
Well, hello everybody. How you doing? So I went to court today for a bench warrant to deal with a bench warrant that was put out for me, allegedly because I didn't make an appearance in court, but I did turn my paperwork in for that. You're allowed to turn in paperwork. You don't have to physically go to court. Paperwork is the same thing as making an appearance.
That claim falls apart immediately because I am not any of the labels being thrown around, and I carry official identification issued by the United States that clearly establishes my citizenship. That document is recognized worldwide and accepted by governments across the globe without confusion or debate. The irony is that every nation understands what a United States citizen is except the imaginary system invented by sovereign citizens. Their arguments exist only in their own circles and have no standing anywhere in the real world or in any real court.
However, they struck it from the record that I made my appearance. They struck the recusal of the judge from the record, and on top of that, they sent me a letter and they stated that I wasn't who I said I was, that I am who they say I am, which when I asked questions about that, the judge yelled at me and told me he didn't have to answer any of my questions. And then when I asked for the bill of particulars and the indemnity bond, I was arrested and taken into custody and held against my will. And so that's a false arrest. But not only was that a false arrest because it's all based on fraud in the first place, but secondly, they didn't read me my rights. I wasn't read my rights by the judge in the court, and I also wasn't read my rights when I was arrested. Also, they did not tell me what my charges were. So there's that. I can't wait to get the paperwork where they tell me what they're charging me with. So this is all because of the right to travel. Okay, it's all based on the right to travel freely, unencumbered, and unfettered according to the Constitution. Now, I'm going to pull up some stuff for you because people need to know what the truth is, and they're not going to really know unless I actually physically show them, because you guys, you're not going to do the research, right? You don't really care. You're just going to tell me I'm crazy and nothing that I say makes sense.
Weren't you literally just taken into custody in the courtroom? Because I'm going to take a wild guess here and say that outcome didn't come out of nowhere. That wasn't bad luck, a setup, or some grand conspiracy. That was a direct result of your own choices. What happened next is entirely on you, and fixing it is your responsibility, not the courts.
You can replay all of this later because it's alive now, but they hold it up for 30 days, and you can write down all of these things if you want to. There's benchmark cases that all deal with all of this stuff, but we'll start with Ohio Revised Code. I was threatened with retaliation for threatened and retaliated against. They were trying to coerce me into basically doing business with the state of Ohio, which I don't have anything to do with. I'm not a state of Ohio resident, okay? Under section 2905, hold on, let me flip this around. Ohio laws and administrative rules, section 2905.12, coercion. No person with purpose to coerce another into taking or refraining from action concerning which the other person has legal freedom of choice shall do the following: threaten to commit any offense, utter or threaten any calumny against any person, expose or threaten to expose any matter tending to subject any person, or hatred, or contempt, or ridicule, or damage any person's personal or business repute, or to impair any person's credit. Institute or threaten criminal proceedings against any person. Take, withhold, or threaten to take, withhold official action, or cause to threaten to cause official action to be taken or withheld. Okay, so anyways, you guys can read all of that. That's the section you need, because that's what happened to me. I am a non-resident alien, according to 5301.254. Okay, you are a non-resident alien unless you are a U.S. citizen, but I'll get to that in a minute. You have the right to the bill of particulars of your case, which I asked for, and they did not give me. And when I asked for it today, and for the indemnity bond, I was arrested. This is the location of the debtor. This is UCC. Do you know who the debtor is? I do. Hold on. It's this. The United States is located in the District of Columbia. They are the debtor. Any foreign bank registered and licensed by a state, which would be all banks, all courts are banks. The United States business. It's a corporation, a partnership. Also, the United States citizen is a corporation or a partnership with the District of Columbia. That's 15 USC 4724E. Here you go. 18 USC 911, citizen of the United States. If you claim willfully and falsely and represent yourself as a citizen of the United States, you are going to be fined and imprisoned, or both. You can only be a citizen of the United States if you are a public servant dealing with the law, so governors, senators, judges, cops. They're all United States citizens. You are not.
Well, when you spend as much time behind bars as some sovereign citizens do, you start getting way too familiar with the law one lonely night at a time on your jailhouse bunk. Alright guys, that wraps up today's video. Every single one of these cases will almost certainly have a follow-up, and when they do, I'll bring it straight to you. If you enjoyed the video, hit that like button. If not, hit dislike, but don't forget to leave a comment below and subscribe with notifications on so you never miss any of my content. And a big thanks once again to Surfshark VPN for sponsoring this video.